Oh, well, here we are again. Welcome, everyone, and thank you for joining me. I am Lior Samfiru, the employment lawyer, and welcome to your employment law session. This is why we're here today to talk about employment law, to talk about workplace rights, and to help you know and understand those rights. Such important rights. We all have a job. We all are interested, I think, should be interested in knowing what our rights are, what the law does for us, what our employer can and cannot do. And on this session, we talk about all those things. I'll tell you what you need to know if you lost your job. I'll tell you what you need to know if your boss is not treating you properly. I'll tell you what you need to know if you're being bullied or harassed in the workplace. You name it, this is the time and place to ask questions. Again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. You'll find my firm across Ontario, BC, and Alberta. And I come here once a week to talk about employment law and to take your questions live. So, yeah, I'm live right now. And if you're hearing me or watching me, you have the opportunity to ask questions. Type it in, hit enter. I'll see it, I'll read it, and I'll answer it. It's that simple, and do it now. You got plenty of time. Don't want to wait till the end of the session, and then you may miss out on having your question answered if I run out of time today. So you have time right now. Let's get those questions answered. I see some questions coming in. I'll start answering them in a moment. Now, before I start answering questions, I want to also give you some other contact information. If you want to connect with me and my team off social media to have a private phone conversation or a private meeting or a private email exchange, very, very easy to do. You just go to employmentlawyer.ca. You see that address below me? It's employmentlawyer.ca. And when you go there, first of all, of course, you can read lots and lots more about employment law and your rights. But you can also get my phone number, my email address is there. If you prefer, you can just fill out a form with some information and we will just call you. Easy to do. It's all right there for you. It's kind of your one-stop shop for anything and everything employment law. Again, employmentlawyer.ca. But you know what? That's for after. Right now, you don't need to worry about that. Right now, I'm here right now with you live answering your questions. I'm going to start right now. So again, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. Understanding that I have to take the time to answer questions. Let's do that right now. Douglas, Boogie D, 47-year-old and on long-term disability, was just cut off at 7 years, still totally disabled, doctor support. What are my chances of any recovery? So very good question. So here's how this works. An insurance company often wants to cut you off because they want to stop paying. They want to get you off their payroll. So they'll look for any reason whatsoever in this world to cut you off, even when it's not appropriate, even when your doctor's supporting you. But that's wrong. If you know you can't work and your doctor says you can't work, your insurance company should not do anything. They should allow you to stay on disability. So what do? Well, the good news is these matters are not difficult to resolve once you know what you're doing. We have a whole team at the firm dealing exclusively and only with these disability issues, with long-term disability and with insurance companies. So here's what I want you to do. I want you to connect with me. I will then have one of my team members discuss this with you. We'll help you make sure you get compensated. Okay, so to connect with me, very easy. Employmentlawyer.ca. Again, employmentlawyer.ca. Don't let the insurance company get away with that. This is money that you're legally owed. That's what you had this insurance policy for, right? So, Boogie D, contact me, employmentlawyer.ca. We've got your back on that. By the way, this is something very common. Oftentimes we see disability insurers deny your claim or they approve it, but then they cut you off before they should. If you do that, you contact me. As an employee, if you have a policy, a disability policy at work, your insurance company doesn't abide by it properly, they don't listen to your doctor, you call me, we'll take care of that. Great question. Thank you for that. Appreciate it. See how easy it is. If you have a question, let's talk about it. That question wasn't directly related to an employer-employee relationship, but still comes out of the employment situation. If you want to know about your boss, if what they're doing is legal, if you want to know if what your company is doing is right, if you want to know how to respond to the company, if they told you you have an ultimatum, you have to do something by a certain date, what to do, what to say, should you even say anything? Ask the question. I'll tell you, and you'll know. All right, continuing to answer questions. Again, I'm Lior Samfiru, the employment lawyer. If you just joined us, let's get some more questions answered. Next question comes to us from YouTube, and this is one from David. My employer continually harasses me, blames me for other employees' mistakes, says I'm refusing training, that I'm not, that humiliates me. Family member employees keep suggesting I quit. Can I stop this? You don't quit. Here's what you do. Number one is you need to find the right person in your workplace to tell this to, whether it's HR, the owner, whoever the right person is above the head of that person that's mistreating you. So you talk to that person, you in writing, you tell them, here's what's happening, here's what I need you to deal with. An employer by law is required to take your complaint seriously, to investigate it, and to fix the problem. They have to. If they don't do that, there could be a violation of several statutes. It's a very big deal. Now, what happens if there's no one to talk to? Maybe it's the owner of the company that's mistreating you. Well, who are you going to talk to? Because it's the owner that's mistreating you. Well, at that point, if you can't deal with it internally, we have to deal with it externally. What that means is you contact me. As long as we can establish and have the evidence that you're being mistreated, that's a constructive dismissal. So we can get you out of there with compensation. If you just walk in and quit, then that's not good enough. You want to be compensated because you deserve to be, because you're not quitting because you just feel like it. You're going to quit because of the way you've been mistreated. So yes, that could be a constructive dismissal. It means you're going to be owed severance. That could be many months' pay. But number one, try to deal with it internally. If you've tried and nothing's happened, or it's impossible to deal with it internally, that's when you contact me and we deal with it externally. So hopefully that makes sense, David, and anyone else. To connect with me, I told you I want you to do that. Very easy to do it. Employmentlawyer.ca. Again, employmentlawyer.ca to connect with me, and let's have that conversation. Okay. Let's see. Question from William. I'm an employee in a unionized workplace. The union dues are deducted from my pay. Yet I was told that I'm not a union member, that if my contract is terminated early, I don't have any recourse. What can I do here? Why am I being made to pay union dues if I don't have any protections? That's not correct. No. If you're paying union dues, then your position is unionized, which means the collective agreement applies to you. You don't have to be a union member. It's a question of whether or not the position you're in is unionized. If it's unionized, then you can't hire a lawyer and you have to abide by the collective agreement, and you have the protections that are available in the collective agreement, whatever they are in your situation. All right, thank you for that question. Again, if you've just joined us, I'm Lior Samfiru, the employment lawyer. See how easy it is to ask questions and get answers. Very, very easy to do. Let's talk about it right now. Let's make sure you get answers. Just like everyone else has been doing. You have time. Let's make sure you get that question answered. Don't wait till the end and then be disappointed. You don't want to be disappointed. That's not good. So let's get the questions answered now. Next question comes to us from YouTube, LQ, who is in BC. My branch is closing. They will be offering me a package or another position at a faraway branch. They're asking me to respond, to choose an option in 5 business days. Is this legal? I think I might qualify for constructive dismissal. Well, it's not a question of how long or how fast they want you to respond. It's a question of what your options are legally. So it's not even a constructive dismissal. It's going to be a regular dismissal. In other words, if you don't stay in the other role, they're going to let you go. So it's not a constructive dismissal. It's just a regular dismissal, which means you're owed severance. So the real question is, how much severance are you owed? So I can almost guarantee you whatever you're owed is going to be more than they're offering you. Now, you haven't told me how long you've worked there. You haven't told me your age or the type of job that you're doing. So I can't assess how much you're owed. But ultimately, if you don't accept the job and they're going to let you go, they have to pay you your full severance. Depending on those factors, you could be owed as much as 2 years' pay. So it's not what they're offering, it's what you're owed. Now, LQ, if you want to give me your age and your position and the length of your employment, I can tell you right now how much severance you're owed. Again, that doesn't matter if they say we'll pay you 3 months severance. It doesn't matter if you're owed 18 months Severance, they'll get 18 months. Okay, so that's the key here. So it wouldn't necessarily be a constructive dismissal, it would just be a regular dismissal. Hopefully that makes sense. But if you're still here, ask that follow-up question or give me those factors so I can assess how much you're owed. Oh, well, there you go. You just said you've been there for 16 years and you're 51 years of age. So you're easily going to be owed a year's pay. And again, you haven't told me what kind of a job you're doing, but it could be as much as 18 months pay if you're in a senior role. Certainly no less than 12 months, and it could be as much as 18 months. Okay, senior technician. So you're probably looking at 14 months, something like that. That's what severance would look like for you, 14 months pay. So ultimately, the choice would be to accept that other role. That's your decision. Or if you don't accept and as a result you lose your job, then you're going to be owed about that 14-month severance. So that's the option. And if you don't get that, you call me and I make sure you get it. As simple as that, okay? Be curious to know what they've offered you, but I can almost guarantee you it's a lot less because that's what companies do. All right, thank you for that question. Next question comes to us from Matthew. I have been on contract for over 2 years. They keep extending my contract by a year. I'm full-time. At some point, am I eligible for the benefits of a permanent employee would get that they don't offer a contract employee? So in terms of whether you get benefits, that is up to the company. The law doesn't distinguish between a contract employee or a permanent employee, and there's no legal obligation to provide benefits. So the company can decide who gets benefits, and that's okay. But here's the thing. You are considered a regular employee. That means that if they decide not to renew your contract at some point, you're probably going to be owed full severance and can be many months' pay. The company may say, oh, we're just not renewing your contract. We're not going to pay you anything. That's wrong. Because you've been there for a while and they keep extending that contract, the law is going to consider you now potentially to be a regular indefinite employee. That doesn't mean you get benefits. That's up to the company. But it does mean you're going to be owed your full severance. Okay, so that could be many months' pay. All right, so very, very important. But also with respect to benefits, it's silly that they don't give you benefits, but legally, a company doesn't have to provide benefits. So they can say, you know what, we're only going to give benefits to A, B, and C, but not to D, E, and F. That's maybe unfair, but legally they can do that. Hopefully that makes sense. By the way, I've already mentioned severance. I was talking to LQ before about severance and how much you're owed. I want everyone to know how you can find out right now how much severance you're owed. It's very simple, and you can find out in seconds how much severance the law says you should have. So what do? Very simple. You go to pocketemploymentlawyer.ca. You see that on the screen below me, pocketemploymentlawyer.ca. And when you go there, you click on the severance calculator. Ta-da, you're there. Once you're in the severance calculator, you can find out, again, in seconds, how much severance you're owed. You answer a few questions, and you'll find out if you're owed 6 months severance, 18 months severance, 2 years, or anything else. It's completely free. It's completely anonymous. And I just saw a question from AB1. How many years of service to qualify for severance? Everyone gets severance. If you had a job and you lost your job, unless you did something horrible, you're owed severance. There's no threshold, even if you worked for a month. Okay? So you get severance. So AB1 for everyone. Go to pocketemploymentlawyer.ca. Click on the severance calculator and find out how much severance you're owed. It's completely free. It's completely anonymous. You don't have to put in your name. You don't have to put in the company's name. You don't have to put in your address, not even an email address, nothing. You just input some information, or you click on the drop-down menu and pick the right answers for you, and it's going to tell you how many months severance you are owed. So a lot of people believe, I have to work a certain number of years. No. A lot of people believe, I only get a week per year or 2 weeks per year. No. It's much more than that. Much more than that. The reason I started doing TV shows and radio shows many years ago is because it drove me crazy that people were believing this false information, that you only get this much severance. Wrong. False. No. Go to pocketemploymentlawyer.ca or call me if you want. You can reach me through employmentlawyer.ca. Let's make sure you get everything that you're owed and that you're understanding what your legal rights are. All right, great questions. Let's continue. But right now, I'm still here with you. Lior Samfiru, that's me, and I am live answering questions about employment law, about workplace rights, about your job, your rights in the workplace. Ask the question. You have time. Still got a good 15 minutes, tons and tons of time. So get those questions answered. All right, KO has our next question. I have found a very promising senior manager position. The contract, however, states that if dismissed, they would do so by providing no more than the minimum statutory notice. If I sign this, am I giving away the ability to ask for more severance down the road? Yes, absolutely. So oftentimes what an employment agreement tries to do is to limit your severance. And because company says, wow, we could owe this person 20 months severance if we let them go. How do we reduce that? Well, you can reduce it maybe if the company has you sign an employment agreement where you agree to accept less. So that's a huge problem. That could literally cost you tens of thousands of dollars. Now, the good news, here's the good news. The good news is that in many cases, maybe 80% of cases where you signed a contract like that, it's still not enforceable for various reasons. There's still things in it that make it unenforceable. That said, you should never sign an employment agreement thinking, well, I'll just sign it because it's going to be unenforceable anyway. No. If you sign it, you have to assume that it is enforceable. So back to your question, KO, if you sign a contract like that, you have to assume that you're potentially giving up future severance, tens of thousands of dollars in the future. Be very mindful of that. Happy to look at it for you if you want, but ultimately, you have to understand what you're agreeing to. Thank you for that question. Really good one, really important one. All right. Continuing to ask, more questions are coming in. Bring them in. Bring them in. I'm not going anywhere, right? So bring them in. So let's see. Question from Scott. My employer wrote an evaluation and used the infraction in the assessment not to renew my contract. The interactions were false, and I was later made aware that a manager was spreading defamatory statements about me. What can I do? Well, it's not a question of whether or not they had a right to let you go, because an employer does have a right to let you go as long as they pay you severance. So the question is, are you owed severance and how much severance? Okay, so obviously I would need to know a lot more, and I would certainly want to know how long you worked there, what your job was, what they say you did you do it, et cetera, et cetera. And on that basis, we need to find out how much severance you're owed and get you that severance. So what I want you to do is I want you to connect with me off air. Again, employmentlawyer.ca. Give that to you again, employmentlawyer.ca. Let's have that discussion, and I'll be happy to help you. By the way, if you're just joining us for the last 12 or 13 minutes, welcome. Thank you so much for joining us. I'm Lior Samfiru, the employment lawyer, and I'm still here live taking your questions. So if you've joined us, still have time to kind of roll up that sleeve, type in your question, hit enter, and I'll see it, read it, and answer it, of course. All right, let's see. Ricky has our next question. Long-term disability was denied and no severance was paid. Well, both of those issues are problematic. If your doctor says you can't work, long-term disability should not be denied. And if you lost your job as a result of that, then potentially that's a human rights violation. And of course, you're owed severance. So there's a lot to digest here. So the good news is my team, we can help you with both those issues. Number one, we can help you with the long-term disability denial. And certainly we can also help you with your employment issue, with the severance. So what you do right now, Ricky, is very, very simple. You go to employmentlawyer.ca. See that address on the screen? It's very easy. Employmentlawyer.ca. There you can pick up the phone number to call me, the email address to email me if you prefer. We'll schedule a time to speak. You'll give me all the information, and we'll get to work helping you, making sure that the insurance company and your employer don't get away with something that's illegal. All right? So, Ricky, you know what to do. Employmentlawyer.ca. I'm looking forward to connecting with you as soon as possible. Don't sit on this, okay? Very important. Okay, let's see. Continuing to answer questions. Thank you so much for the questions, guys. Bring them on. I'm still here. Challenge me. Let's get those questions answered. Stevie has a question. What happens if your employer places you on a performance improvement plan? So the question is it justified or not? If it's justified, you weren't doing a good job, etc., then you do the best you can to improve your performance. That's all you do. If you don't think it's justified or fair or accurate, what I want you to do is say so, and say so in writing. I want you to send an email to your employer and saying, you put me on a performance improvement plan for these reasons. Here's why I don't agree with it, or here's why it's not accurate, or here's why you didn't consider this other information, and tell them all the relevant information. Now, you have to be professional. You don't have to be aggressive or argumentative, but you have to say that. By saying that, you're going to make it very difficult for the company to use that performance improvement plan as a basis to let you go. If you don't say anything, it's the same as you agreeing to it. And if you agree to it, it can be held against you. So if it's all accurate, it's all legitimate, all you have to do is do the best that you can with your job. If it's not accurate, it's not legitimate, it's not full, etc., say so in writing. Don't be silent. Don't just put your head down and continue working. And if you lose your job, either way, you call me, and you call me immediately. Because guess what? Even if your performance is not great, if you lose your job, you're still going to be owed severance in almost every case. It's extremely difficult to let someone go without severance. It's not enough for the company to show that maybe your performance was not up to par. That's not enough. So if you lose your job, performance improvement plan or not, you call me, and you call me immediately. And that contact information, of course, is at employmentlawyer.ca. See that on the screen, employmentlawyer.ca. Guys, thank you for that. Let's continue questions. Still have some time here, plenty of time. So I love it when questions come in, and I want to take your question as well. Best name for the day. The award goes to Hobby Lover. Perfect. Next question by Hobby Lover. I am planning to quit my job because my store manager and other managers hate for unknown reasons. They do not talk to me. Store manager put me on a performance improvement plan, wrote me up, and gave me unrealistic goals. So rather than quit, number one, I want you to respond to this performance improvement plan. I was just saying that a second ago. If the goal's unrealistic, say so. If you don't agree with the write-up or the performance improvement plan, say so. The other thing is, if you think you're being mistreated by the store manager, then I want you to say so to HR or the district manager or regional manager, whoever's above their head. You want to write a nice email saying, here's why I feel I'm being mistreated or harassed or bullied, and I want you to do something about it. They have to deal with it. Because wouldn't it be fantastic if those problems get resolved? So why quit, right? If they don't resolve the problems, or it gets worse, or they ignore you, you call me, and we can still get you out of there, but with compensation. So do the things that I told you first. Respond to the performance improvement plan, talk to HR or the regional manager in writing, and then if all else fails, you call me, and I'll make sure that we get you out of there with compensation. Okay, Hobby Lover, thank you. That's a great question. I appreciate you taking the time, and you know what to do. And of course, when you need to connect with me, I give you that address. I'll give it to you again, employmentlawyer.ca. Right, let's see. More questions. I want to answer them all. So LQ has a follow-up question. Okay, the faraway branch is about 1.5 hours additional commute round trip. The previous commute was 15-minute round trip. Can I refuse the position as the commute is too long and get full severance? Yes, you can. Absolutely, you can. But here's what I want you to do. Before you say yes or no, I want you to connect with me and my team off air. I want to find out more about your job, etc. See any employment agreement that you may have signed, because we want to dot our I's and cross our T's, right? We want to be specific. We need to do this correctly. Because if we don't do this correctly, guess what? You're taking a risk. So the short answer is yes, you can refuse it. But before you refuse it, call me. Okay, employmentlawyer.ca to get the phone number, and be happy to connect, and we'll have that discussion. Thank you for that. All right, let's see. I think we have time for some more questions here. So last chance for you to ask it, okay? If you've been sitting on the fence, should I ask, should I not? What are you waiting for? Ask the question right now. I'm still here, and you can still get that question answered. All right, AB1, I think, has another question. Can an employer terminate your employment a few weeks after returning from compassionate care leave? I have been with the company full-time for 11 years. They can, as long as the reason that they're letting you go is not because you took that leave. So if the reason is not because that's unrelated to that, then they can let you go. If they're letting you go to punish you for taking compassionate care leave, then that would not be legal. Okay, that could be a reprisal. So that's the real question here. Otherwise, they can let you go. Now, you've been with the company for 11 years. Now, I don't know your age, and I don't know how long, I don't know what kind of job you're doing, but you could be owed easily a year's pay. Okay, that could be what severance is owed to you. So either way, if you lose your job, regardless of what we think of the reason, you got to call me because we have to make sure you get that severance. It could be easily a year's pay, depending on those factors. It could even be more than a year's pay. So you want to connect with me as soon as possible, AB1. Again, you know the address, employmentlawyer.ca to do that. And all the contact information is still there. By the way, if you've just joined us, this has been and is continuing to be your employment law session once a week. Me, Lior Samfiru, I'm here talking to you about employment law, workplace rights, informing you and arming you with the knowledge that you need to have if you have a job. So AB1 says you're 47 years old doing admin work. So yeah, 10 to 12 months of severance is what you'd be owed. So that's what severance looks like for you. And remember, they can't let you go because you took that compassionate care leave. That would be illegal. If it's unrelated, then they absolutely can, but they have to pay you that severance. All right, let's see. Next question today from Bill. Bill says, I have been terminated without cause and been offered 8 weeks working severance. I have been with the company for 8 years and have been in a supervisor role for the last 2 years. I'm 56. Am I owed anything more? Absolutely. So that 8 weeks working severance, so sometimes we call that working notice that you got, does count towards your severance. But after 8 years in a supervisor, 56, you're probably owed about 9 months of severance. So they're giving you 8 weeks, you're owed 9 months. That's a massive difference. So they owe you 9 months less the 8 weeks, minus the 8 weeks that they've given you as working notice. So yeah, that's still another 7 months or so pay that they owe you. So Bill, yeah, you know what to do. You connect with me as soon as possible, employmentlawyer.ca to do that. And I'll help you get it. Simple as that. Good time to ask that question because, yeah, you're owed much, much more. Employmentlawyer.ca, connect with me and my team. Let's get to work. Let's see. Ricky says, I settled my long-term disability denial already. The employer frustrated my employment contract and paid no severance. I initiated a human rights complaint, now pending mediation. Employer is a huge Canadian corporation. Well, you can contact me, Ricky. That's what I can do. I mean, whether or not this is frustration or contract, I would need to know what your prognosis was. If your doctor was saying there's no hope of you coming back to work, and I think you've been off for 7 years, then that could be a frustration of contract, and it wouldn't be a human rights violation. So I would need to know more about it. So that's why you contact me through employmentlawyer.ca. All right, last question for the day from Lisa. I'm currently off on short-term disability due to stress. My work environment was becoming increasingly toxic with unrealistic expectations and verbal harassment. I did verbally complain, but nothing was done. I'm wondering what my rights are and what my next step should be. So verbal complaint, not good, because you need to have the proof in writing. I want you to do the same thing, but in writing. Complain in writing, providing details. Here's what's happening. Here's what's involved. Here's the dates, and please do something about it. If they don't do anything about it, that's when you call me, all right? That could be a human rights violation. It could be a constructive dismissal. I deal with that. But what you don't want to have happen is for the company to say, oh, we didn't know. You didn't tell us. And if you told them verbally, they can lie and deny it, and you don't have any proof. So that's why you always put it in writing. Okay, I want you to send that email in detail outlining what's happening. And then if they don't deal with it properly, I'm here. I got your back. employmentlawyer.ca to connect. Okay, employmentlawyer.ca. Okay, guys, this was the time that we've had for today. Lots of questions. I love it. Love the questions. Want to answer as many as possible. I'll be back next week, but don't wait until then. I give you my contact information 10 times. Let me give it to you one more time. employmentlawyer.ca. How easy is that, right? employmentlawyer.ca to connect with me and my team. Get us to roll up our sleeves, get to work to actually help you enforce your legal rights. It's one thing to know what your legal rights are, very important, of course, but it's another thing to actually go ahead and enforce those rights. That's where we come in. So again, employmentlawyer.ca. Thank you so much, guys, for the great questions. Always a pleasure and a privilege to be here with you. I'll be back next week. Looking forward to connecting. Have yourself a great rest of the week. Bye, guys.